Chapter 17, Discharge of Negotiable Instruments. Section 181. In general, some writers treat this subject under the head of defense while others treat it as the performance of an obligation contracted. It will be treated here largely in the nature of a discharge of a contract. The Negotiable Instruments Law provides, as follows: a negotiable instrument is discharged 1. By payment in due course by or on behalf of the principal debtor. 2. By payment in due course by the party accommodated, where the instrument is made or accepted for accommodation. 3. By the intentional cancellation thereof by the holder. 4. By any other act which will discharge a simple contract for the payment of money. 5. When the principal debtor becomes the holder of the instrument at or after maturity in his own right. Section 182. By payment. Negotiable instruments may be discharged by payment. This is the most usual way of perfecting a discharge of the bill or note. The very nature of the word payment indicates that it is a discharge of a contract. To pay money by giving to the party entitled to receive it the amount agreed to be paid by one of the parties to the contract. Payment is not a contract but is rather a manner of discharging a contract in which one party has a right to demand a sum of money and in which the other party has a right to receive the money. Then by payment is meant the discharge of a contract to pay money by giving to the party entitled to receive it the amount agreed to be paid by one of the parties who entered into the agreement. Payment as stated above is not a contract. It is the discharging of a contract in which the party of the first part has a right to demand payment, and the party of the second part has a right to make payment. A sale is altogether different. It is a contract which does not extinguish a bill or note, but continues it in circulation as a valid security against all parties, and it is necessary to constitute a transaction a sale that both parties should expressly or impliedly agree, the one to sell and the other to purchase the paper. Whether the transaction is a purchase or payment is a question for the jury where the facts are in dispute, to be resolved according to the intention of the parties, by looking to the substance of the matter rather than its form. Payment is usually made by the principal debtor and is a complete discharge of the instrument, that is, a negotiable instrument is discharged by payment in due course by or on behalf of the principal debtor because it is the performance of a contract according to its terms by the person primarily liable. Payment may be made by any other person than the principal debtor, but in order that he may in turn recover from the maker it is necessary for him to ascertain whether there has been presentment, protest and notice, because in default of these steps in this particular case the maker would not be liable to him. It is also advisable for him to inform himself as to the identity of the holder and determine as to whether or not he has the legal title to the instrument, and payment to him in due course discharges the instrument. Payment always discharges the instrument when made to the proper party, but it does not discharge all the parties. The principal debtor must pay the amount of the instrument before he is discharged. But it must be understood that not anyone who desires may pay the instrument and then recover of the maker. He must be a person who has in some way made himself liable for the payment of the instrument. There is however one exception to this, and that is where an instrument has been protested and someone comes in and makes payment super protest or for honor. A negotiable instrument is discharged by payment in due course by the party accommodated where the instrument is made or accepted for accommodation. Any party to a bill or note may pay it, and an endorser who has been discharged by failure of notice may still sue a prior endorser or other parties who were not discharged, because, although not compelled to pay it, he acquires the right of the holder from whom he took the instrument, or is remitted to his own rights as endorsee. A mere stranger to the paper cannot make payment without the consent of the holder unless he represents a party liable thereon, or makes payment super protest. Where payment is made by a party who is not the primary obligor or an accommodation party, his payment only cancels his own liability, and those who are obligated after him. All prior parties, primarily or secondarily liable on the bill, are liable to such a payer, and the payer may cancel endorsements subsequent to his own and reissue the paper, and it will be valid as against the prior parties. The Negotiable Instruments Law covers this by the following provision. Where the instrument is paid by a party secondarily liable thereon, it is not discharged, but the party so paying it is remitted to his former rights as regards all prior parties, and he may strike out his own and all subsequent endorsements, and again negotiate the instrument. except 1. Where it is payable to the order of a third person, and has been paid by the drawer, and 2. Where it was made or accepted for accommodation, and has been paid by the party accommodated. Payment of a bill or note should be made to the legal owner or holder thereof, or someone authorized by him to receive it. If it be payable to bearer or endorsed in blank, any person having it in possession may be presumed to be entitled to receive payment, unless the payer have notice to the contrary, and a payment to such person will be valid, although he may be a thief, finder or fraudulent holder. Payment is made in due course when it is made at or after the maturity of the instrument to the holder thereof in good faith and without notice that his title is defective. The maker of a note or the acceptor of a bill must satisfy himself, when it is presented for payment, that the holder traces his title through genuine endorsements, for if there is a forged endorsement it is a nullity and no right passes by it. The party making payment should insist on the presentment of the paper by the party demanding payment, in order to make sure that it is at the time in his possession, and not outstanding in another. And if at the time he makes payment it is outstanding, and held by a bona fide holder for value, he will be liable to pay it again, and a receipt taken will be no protection. The party making payment of the bill or note should also not fail to insist upon its being surrendered up, as a voucher that the party receiving the money was entitled to do so and also that he has paid it to him. The party bound to make payment has no right to do so in any other medium than that expressed on the face of the instrument, that is, he must make payment in money. When payment of a bill or note is made by giving another note or bill, other than notes treated as legal tender, as a general rule, such payment will not be considered absolute until the paper given in payment has been itself paid, except where the parties expressly or impliedly agree that the claim shall be discharged by such payment. A distinction is made by some authorities when the payer gives his own note in payment and when he gives the note or bill of another. In the first instance it is uniformly treated as a conditional payment. When a stranger's note is given in payment for a precedent debt it is also generally treated as a conditional payment, but if given in satisfaction of a contemporaneous debt it is held to be an absolute payment if so transferred as to end the transferor's liability thereon, that is, without endorsement. A new bill or note given in renewal of an old one retained by the payee is also held to constitute but a suspension of the old one until the new one is paid. The conditional payment operates to suspend the right of action on the original paper until the paper taken in payment falls due, then the holder can sue, at his election, on either of the obligations. A part payment of a bill or note which has fallen due only extinguishes it pro tanto, and an agreement that it shall be in full discharge of the debt does not make such part payment any more effectual as to the residue, there being no sufficient consideration for the discharge of the whole. But any agreement by way of compromise or composition, into which any new element entered, would be sustained, and if the claim were disputed, agreement to receive part payment in full would discharge it. Section 183. By payment for honor. Where a bill has been protested for non-payment, any person may intervene and pay it super protest for the honor of any person liable thereon or for the honor of the person for whose account it was drawn. The payment for honor super protest, in order to operate as such and not as a mere voluntary payment, must be attested by a notarial act of honor which may be appended to the protest or form an extension to it. The notarial act of honor must be founded on a declaration made by the payer for honor or by his agent in that behalf declaring his intention to pay the bill for honor and for whose honor he pays. Where two or more persons offer to pay a bill for the honor of different parties, the person whose payment will discharge most parties to the bill is to be given the preference. Where a bill has been paid for honor, all parties subsequent to the party for whose honor it is paid are discharged, but the payer for honor is subrogated for, and succeeds to, both the rights and duties of the holder as regards the party for whose honor he pays and all parties liable to the latter. Where the holder of a bill refuses to receive payment supra protest, he loses his right of recourse against any party who would have been discharged by such payment. The payer for honor, on payment to the holder of the amount of the bill and the notarial expenses, incidental to its dishonor, is entitled to receive both the bill itself and the protest. Section 184, by cancellation and surrender. The second method by which an instrument may be discharged is by cancellation and surrender, where the person who is entitled to receive payment delivers up the instrument which he holds against another with the intent and for the purpose of discharging the debt. This surrender operates as a release and discharge of the liability thereon in the absence of fraud or mistake. It is set out in their Negotiable Instruments law that a negotiable instrument is discharged by the intentional cancellation thereof by the holder. No consideration is necessary to support such a transaction after it has been executed. Where the return or surrender of a note is induced by fraud, the maker is not released from a liability thereon, and where a note has been surrendered by mistake upon the supposition that it was fully paid, the maker will remain liable for the balance still unpaid. The holder may waive his right to payment by cancellation. Cancellation of an instrument may be made by destroying it or by any other means by which the intention to cancel the instrument may be evidenced. A cancellation made unintentionally, or under a mistake, or without the authority of the holder, is inoperative, but where an instrument or any signature thereon appears to have been cancelled, the burden of proof lies on the party who alleges that the cancellation was made unintentionally, or under a mistake or without authority. Cancellation may be made before maturity, but in order to be effective in such case against a bona fide holder it must carry notice to him of such cancellation upon its face. Section 185. By covenant not to sue, the maker or acceptor may be discharged from the payment of the instrument by a general covenant not to sue, and, of course, if the maker is discharged, the endorsers will also be discharged. Such a covenant is a discharge of the instrument as to these parties, but such a covenant will not discharge another who is jointly liable with the covenantee. If the covenant is given by one of two creditors it will not operate as a release or a discharge of the instrument. A covenant not to sue for a limited time will not discharge the instrument as between the parties, but it does release the sureties. Section 186. By accord and satisfaction. In considering the question of accord and satisfaction a distinction should be made between an extinguishment and a satisfaction of a bill or note. This has been very clearly stated by Justice Story in the following words: taking a security of a higher description, such as a bond or judgment, will extinguish the claim of the holder upon the note against the party giving the security, but it will not amount to a satisfaction thereof, so as to discharge the other parties upon the note. Any person to whom the maker is liable on an instrument who makes an agreement with the maker not to sue has caused the instrument to be extinguished as to himself, but there is no satisfaction as to the other parties to the note. Whatever the payee of the instrument receives from the maker in full satisfaction of his claim is a satisfaction as to all other parties who might have been held liable. Where the debt or demand is liquidated, that is, where it is a sum certain, the payment of a less sum by the debtor and a receipt therefore by the creditor is not in accord and satisfaction of the debt, although the creditor agrees to accept it as such. Such would not be the case, however, if the sum was in dispute or was an unliquidated sum. Section 187. By substitution of another obligation, a bill of exchange or promissory note may be discharged by the substitution of a new obligation for the pre-existing one. Some writers treat this subject under the head of novation. In these cases the extinguishment of the old debt is sufficient consideration for the new obligation. It is essential that the new obligation be such as may legally take place in order that it may extinguish or discharge the prior obligation. There may be a sufficient consideration and competent parties to the substitution obligation, but if the new obligation is one which cannot legally take place the prior instrument is not discharged. It is permissible at any time before the contract of substitution is complete, for the parties to withdraw from the arrangement, but after such completion, none of them, without the consent of all the others, may withdraw from or rescind or in any way modify the new contract existing between them. The entire doctrine of substitution and the legal effect thereof depend upon the agreement between the parties and is governed by the general laws of contracts. Section 188. By alteration. The general rule as to whether or not the alteration of a bill or note will operate as a discharge of the instrument depends upon the effect produced upon the instrument by such alteration. If the alteration is immaterial it is held not to be a discharge, while, if it is a material alteration, it is held to be a discharge of the instrument as to all the parties liable except as to the party who has himself made, authorized or assented to the alteration. Where a negotiable instrument is materially altered without the assent of all parties liable thereon, it is avoided, except as against a party who has himself made, authorized or assented to the alteration and subsequent endorsers. But when an instrument has been materially altered and is in the hands of a holder in due course, not a party to the alteration, he may enforce payment thereof according to its original tenor. Any alteration which changes, 1. The date, 2. The sum payable either for principal or interest, 3. The time or place of payment, 4. The number or the relations of the parties, 5. The medium or currency in which payment is to be made, on which adds a place of payment where no place of payment is specified, or any other change or addition which alters the effect of the instrument in any respect, is a material alteration. If the alteration is made before the delivery of the instrument, it will not operate as a discharge of it. If a person after full knowledge of an alteration unconditionally promises to pay the instrument, it is considered a sufficient ratification and will not be construed as a discharge of the instrument to this particular party. Where the alteration is made by a stranger to the instrument, the rights of the parties are not affected and there is not sufficient ground for a discharge. Section 189. By the principal debtor becoming the holder in due course, the instrument is discharged if, when it matures, the acceptor or maker is or becomes the holder, since the right to recover upon the instrument and the liability to pay the instrument are coincident in one and the same person. In order that payment or coincidence of right and liability should operate as a discharge, it is essential that the instrument should have matured. A negotiable instrument is discharged when the principal debtor becomes holder of the instrument at or after maturity in his own right. An acceptor or maker may acquire it before maturity, as purchaser, and may then further negotiate it. Section 190. By operation of law. An instrument may be discharged by operation of law. If a judgment is obtained on a bill or note, the bill or note is thereby extinguished and merged in the judgment. The judgment alone, without actual satisfaction, is no extinguishment, as between the plaintiff and other parties not jointly liable with the original defendant, whether those parties be prior or subsequent to the defendant. The issuing of execution against the person or property of one party to a negotiable instrument does not extinguish the plaintiff's remedy against the other parties. The intermarriage of the maker of a note with the payee or holder will, unless otherwise provided by statute, discharge the maker from all liability thereon. A discharge in bankruptcy, unless otherwise provided by statute, releases a bankrupt from all his provable debts, and therefore will discharge the bankrupt, on all bills accepted, or notes made by him, but will not discharge the other parties. Section 191. By renunciation by holder. The negotiable instruments law provides that, the holder may expressly renounce his rights against any party to the instrument, before, at or after its maturity. An absolute and unconditional renunciation of his rights against the principal debtor, made at or after the maturity of the instrument, discharges the instrument. But a renunciation does not affect the rights of a holder in due course without notice. A renunciation must be in writing, unless the instrument is delivered up to the person primarily liable thereon. Section 192. When a person secondarily liable discharged. A person secondarily liable on the instrument is discharged by any act which discharges the instrument. By the intentional cancellation of his signature by the holder. By the discharge of a prior party. By a valid tender of payment made by a prior party. By a release of the principal debtor, unless the holder's right of recourse against the party secondarily liable is expressly reserved. By any agreement binding upon the holder to extend the time of payment, or to postpone the holder's right to enforce the instrument, unless made with the assent of the party secondarily liable, or unless the right of recourse against such party is expressly reserved.